All right. Environmental Protection Agency. Title 40 CFR Chapter 17119. Part 22, Subpart H, Supplemental Rules 2233, Reserve 2234, Supplemental Rules govern the Ministry of the Assessment of the Civil Penalties for the Clean Air Act. Scope of the section shall apply with the conjunction 22.1 through 2232. Administrative proceedings, the staff of the Civil Penalty conducted under section of 113D, 205C, 211D, 213D of the Clean Air Act amended and 7547D with the determination of non-conforming engine vehicle with equipment under Section 207C and 213D of the Clean Air Act is amended, whether inconsistent with existence between Section 22.1 and 2233. 2232 section shall apply with the issuance of the notice prior to the issuance of the final order assessing the civil penalty for final determination of non-conforming engine vehicles equipment. The person to whom the oral determination is to be issued shall be given the written notice of the proposed issue of the order of the determination, serve as compliant with the consistent with the agreement, final order pursuant to 2213, satisfied with the notice of the requirement. 2235 supplemental rules govern the Ministry of the assessment of the civil penalties of federal intesticide, fungicide, rodent, and pesticide act. This section applies with the conjunction 22, 22, 32 of the Administrative Procedure for the set of the civil penalties conducted under Section 14A of the Federal Intesticide, Fungicide, and Rodenticide as amended, where inconsistent exists between the sections 22.1 through 22.32, the section shall apply. Venue. The pre-hearing conference of the hearing shall be held with the county, with the parish, the incorporated, the state, with the resident, with the person in charge, unless otherwise agreed with the writing, with all parties, with the person who, with the resident, it's outside of the United States, with outside of the territory, possession of the United States, with the pre-hearing conference of the hearing shall be held with the EPA of the office listed in Title 40 CFR 17 with the close of the other, a person with the primary place of the business within the United States, with the primary place of the business of the person, U.S. agent, with the unless otherwise agreed upon by all parties. 2236 of the Reserve, 2237 of the Supplemental Rules governing the administration of the proceeding of the Solid Waste Disposal Act. The section shall apply with the conjunction 22 through 1 through 2232 for the administrative procedure with the section 3005D and E and 3008, 9003, 9006 of the Solid Waste Disposal Act, and where inconsistent exists between the section 22.1 and 23.2 of this section shall apply. Corrective action complying with the complaint with the compliance order issued under section 3008D and 9006A with the corrective action order issued in section 3008H and section 9003H4 of the Solid Waste Disposal Act. Any such orders automatically become final order unless not no later than 30 days after the order is served with the respondent with the request of the hearing pursuant to 2215. 2238 Supplemental Rules governing the administrative assessment of the civil penalties of the Clean Water Act. The section applied with the conjunction 21 through 2232 and 2245 of the administrative proceed with the assessment of any civil penalty under section 309G with the section 311 of the B61 Clean Water Act and 1321B6. The consistent exists between the section 22.1 through 2232 of the section shall apply. Consultant with the saints. Proceeding pursuant with the section 309G with the compliance shall provide with the chair of the agency for the most direct authority of the matters of the issue and the gave the opportunity to consult with the complainant. With the complainant shall notify the state agency within 30 days of the filing proof of the service of the complainant with the respondent with the case of the proceeding proposed of the commence of the pursuant of the 7213B with no later than 40 days before the liaison with the order of the assessment of the civil penalty. Administrative procedure for the judicial review action of the administrative review for the rule could have been obtained under section 509B1 of the Clean Water Act of Title 33 U.S. Code 1369B1 shall not be subject to the review of the administrative proceeding with the assessment of civil penalty under Section 39GB G and Section 311B6. 2239 Supplemental Rules govern the administrative assessment of civil penalties under Section 109 Comprehensive Environmental Response Compensation Liability Act of 1980 is amended. The scope of section applied with the conjunction 2210 with 2232 with the administrative proceeding with the assessment of civil penalties under Section 109 Comprehensive Environmental Response Compensation Liability Act of 1980 as amended where inconsistent with existence with the Section 22.1 through 2232 of the section shall apply. Judicial review any person who has requested for the hearing with respect to the Class 2 civil penalty under Section 109B Circular Act of Title 42 U.S. Code 9609B with the recipient final order assessing the civil penalty with the final petition for the judicial review of such order of the United States Court of the Appeal for the District of Columbia or any other circuit with which the person resides of the transact business and the person requests for the hearing of subject respect with the Class 1 civil penalties under Section 109A4 Circular Title 40 U.S. Code 9609A4 with the recipient with the final order assessing the civil penalty may file the petition with the judicial review of such order appropriate District Court of the United States. All petitions must be filed within 30 days of the day of the order of the making assessment was served and on the parties. Penalty of the civil penalty assessed. The civil penalties assessed in the final order shall be made with the forward of the check cashier's check payable to the EPA as a substance superfund and amount of the assessing the noting of the case title of the docket number appropriate to the regional superfund lockbox depository. All right, 2240. Reserve 2241. Supplemental rules govern the administrative assessment civil penalties. Title 2 Toxic Substance Control Act of the Act and Section 2 of the Aspect of the Hazard Emergency Response Section Act. All right, the section should apply with conjunction 22 to 2232 for the administrative procedure with the civil and conduct with the under Section 207 Toxic Substance Control Act, and which of the inconsistent between the Section 22.1 through 22.32 section shall apply civil penalties, collection of civil penalties collected with the Toxic Substance Control Act, Section 207 that shall be with the local educational agency the purpose of the complying with the Title 2 Toxic Substance Control Act. Any portion of the civil penalty remaining unspent with after the local education agency to achieve the compliance shall be deposited with the asbestos trust fund as established under Section 5 of the HERA. All right, 2242 supplementals rules govern the administrative assessment, civil penalties, violation, compliance order for the owner for the operator of the public water system of the one in Part B with the Safe Drinking Water Act. Scope of the section shall apply with conjunction 22.1 with the 2232 for the administrative presides for the civil penalty under section 1414G3B with the Safe Drinking Water Act, Title 40 U.S. Code 300G3 G3B with the contingency of the exists between the section 22.1 through 2232 with the section shall apply. Choices of forum. Complainant shall specify the subpart I with the part shall also state the respondent has the right to elect with a hearing on the recorded accordance with the Title 5 U.S. Code 554 with the respondent waive the right unless requests its answer hearing on the record in accordance with the Title 5 U.S. Code 554 and such request of the request hearing shall recapture the documents of the record with the necessary to notify the party of the changes. All right, 2243 supplemental rules govern the administrative assessment of the civil penalties against the federal agency for the Safe Drinking Water Act. The section applied with the conjunction 22.1 through 2232 for the administrative procedure for the civil penalties and federal agency for the under section 1447 of the B Safe Drinking Water Act, Title 40 U.S. Code 300J6B, where inconsistency exists between section 22.1 through 2232. The section applies effective date of the final penalty order. The penalty order pursuant to the section selection 1447 of the B of the Safe Drinking Water Act shall completely be effective for 30 days after it has been served on the parties. Public notice of the final penalty or of the issue of the final penalty under this section. Administrator shall provide the public notice of the order for the publication for the providing for the notice of any of the parties from requesting such of the notice. The notice shall include docket number for the order, the address, the phone number of the regional hearing clerk from whom the copy of the order may be detained, the location of the facility where the violations were found, a description of the violation penalty that was assessed, and the notice of the interested person within 90 days of the day of the order becomes the final or obtain judicial review the penalty order pursuant to section 1447 of the B Safe Water Drinking Act instruction with the person seeking the judicial review with the such of the provided copy of the appeal with the person provided described in Title 40 CFR 13511A. All right, 2244 supplemental rule of the fact of the government termination permits under Section 402A with the Clean Water Act under Section 3008A3 with the Resource of the Conservation Act, Recovery Act. Scope of the part supplemental review of the practice subpart, but they should also be in conjunction consolidated rules of practice for the part with the administrative proceeding with the termination of the permits under Section 402A of the Clean Water Act under Section 3008A3 of the Rules Conservation Recovery Act with the nothing consolidated rule practice with the supplement of the rules governing with respect with the termination of the permit and proceeding with the terminate the permit for the cause of 12264 and 27043 with the chapter for the during with the term of the permit of the complaint shall addition with the requirements of 2214B containing the additional information specified in 124D with the chapter the director is defined in 124.2 of the chapter provided the public notice for the complaint with the accordance with 124.10 with the chapter for the and also public comment in accordance with 124.11 then with the proceeding of the chapter. Presiding officer shall admit the evidence of the contents of the administrative record described in 124.9 with the chapter any of the public comments received. 2245. The supplemental rules cover the public notice comment with the proceeding under Section 309G with the 311B, 6B, 2 of the Clean Water Act and Section 1423 of the Safe Drinking Water Act. Scope of the section applied with the conjunction 21 through 32 with the administrative proceeding for the assessment of the any civil penalty under Section 309G with the 3011 the B62 B2 of the Clean Water Act and the under section of the 1423 of the Safe Water Drinking Act, where it is inconsistent exists between section 21 through 22.1 and 22.32 sections shall apply. Our public notice. General of the complaint shall notify the public before the assessing civil penalties of the such notified provide for 30 days for the following proof of the service of the complaint with the respond with the indicate for the proceeding, the proposal of the complaints for the pursuant 2213B with no less than 40 days for the bid for issuing any order assessing civil penalties with notice for the period of the guns for the first publication of the notice, the type of the content of the public notice for the complaint, to provide public with a notice for the complaint or to the proposed consent agreement by method of reasonably calculated provided notice shall also provide the notice of the directly to the any of the person requesting such a notice. The notice shall include the docket number of the proceeding, the name of the address of the complaint, and respond on the person with the information for the proceeding, with the maybe the name with the address of the regional hearing clerk with the appropriate comments if they will be directed, location of the site of the facility, violations are alleged for the applicable permanent number of the description of the violation alleged, release off the notice of the person shall be comments of the regional hearing with the clerk of the deadline for the submission. Comment if the person is not with the party with the following provisions apply with regarding with the comment with the person not with the party with the proceeding. Participating in the proceeding, any with the person participating with the proceeding must notify the regional hearing clerk written within the public notice proceed period under paragraph B1 of the section. The person must provide his name with the complete mailing address of the state of which he wishes to participate in the proceeding. Presiding officer shall provide the notice to any of the hearing of the merits of any for the person who meets with the requirements of paragraph C11 of this section at least 20 days prior to the scheduling of the hearing. The contenter may present a written comments of the record for the time period of the close of the record. For the commenter wishing to present the evidence of the hearing of the merits shall notify the writing of the presiding officer party for the intent at least 90 to 10 days prior to the reschedule for the hearing of the notice may include with a copy of the document introduced with the description and evidence of the presented, identify any of the witness qualifications of if an expert with the subject matter of the testimony. If any of the hearing merits of the commenter may present evidence including the direct testimony subject to the cross-examination of the party of the presiding officer shall have the discretion established with the consent of the commenter participation in any of the other scheduled activity. Limitation. Commenter may not cross-examine the witness if the hearing but shall not be subject to participate in the discovery of the pre-hearing exchange quick resolution settlement of the proceeding. Subject to public notice of the commitments for the provision paragraph B and C for the section may be resolved and settled in 2218 or commenced under 2213B within 10 days after the commandment of the period provided in paragraph C1 of this section. Petition to set aside consent with agreement with the proposed final order. The complaint with it shall provide each of the commenter with a certified requirement return receipt requested and notified by the regional hearing clerk of the presiding officer of the copy of the inconsistent agreement between the parties within proposed final order within 30 days of the receipt of the consent of the order proposed the final order commenter with the position with the regional administrator for the copy of the commencement for the EPA headquarters for the Environmental Appeals Board and to set aside with the consent agreement with the proposed final order on the basis of the material evidence for the non-consent of the copy of the position shall be served with the parties and will not be in consent. The regional hearing clerk with the presiding officer within 13 days of the receipt of the petition for the complaint must not notice within the regional administrator of the Environmental Appeal Board to the command manager with withdrawal of the consent of the agreement with the proposed final order to consider the matters were raised for the petition of the complaint. If it does not give the notice within 15 days of the receipt of the petition, the regional administrator of the Environmental Appeals Board shall assign the petition officer for the consider of the rule of the position. The position officer shall be another presiding officer, not otherwise involved with the case. No, for the assignment, it shall be sent with the party for the presiding officer the 30 days of the assignment of the position of the complaint, which shall be present within the position of the copy of the complaint with a written response of the position, copy of the response shall be provided with the party for the commenter and to the commenter, but not to the regional hearing clerk or the presiding officer. The position officer shall review the position compliance, respond with the shall file with the regional hearing clerk with copies of the priorities of the commenter for the presiding officer written findings as well to the extent in which the position issued with the relevant material for the issue of the proposed final order, which complaint with adequately consider the respond with the position with the resolution of the proceeding of the party with the property without hearing. Upon finding the position officer of the hearing is inappropriate, the presiding officer shall offer with a consistent agreement with the proposed final order to set aside shall establish a schedule of the hearing upon finding of the petition officer for the resolution of the proceeding with or without hearing an appropriate petition officer shall issue the order to deny the position stating the reason for the denial. The position officer shall file with the order within the regional hearing clerk, serve the copy of the order for the party for the commenter, provide public notice of the order upon finding of the position of the officer of the resolution proceeding without the hearing is appropriate with the regional administrator may issue the proposed final order, which shall become within 30 days of the final order with the order denying the position with the proposed signing consent agreement or file with the regional hearing clerk with unless otherwise position with the review with the file with the notice and appeal with the property United States District Court of the coincides the notice of certified mail administrator of the Attorney General written notice of the appeal shall be filed with the regional hearing clerk same with the presiding officer and parties if the judicial review of final orders denied, the final order shall become effective for 30 days after the certificate of denial has been filed by the regional hearing clerk. 2246 through 49 is reserved. Subpart I, administrative proceedings not governed by Section 554 of the Administrative Procedure Act.